My name is Thomas Burrell, and I am the president of the Black Farmers and Agriculturalists Association, Incorporated. This is video number 6. In video number 6, we're going to be talking about, among other things, an order that was signed by one of the judges in one of the class action lawsuits. And if you look at the top upper left-hand corner, you'll see it's case number 1-08-MC-00511-PLF. Paul L. Friedman is the judge in the second lawsuit. Recall now, we've had 5 lawsuits. We had Timothy C. Pickford et al. Versus Dan Glickman. We call that Pickford 1. And then in 2008, Congress passed legislation that blew life, as it were, into a class of individuals who were determined as late filers by Judge Friedman, and in particular, one of the mediators, an attorney by the name of Michael K. Lewis. Michael K. Lewis said that everybody who tried to get in Pickford 1 but missed the deadline, which he said was October the 12th of 1999, and there were roughly about 66,000 individuals who filed late, and they were accordingly designated as late filers. And then they were allowed to proceed in, as we said, as a result of the Farm Conservation or Food Conservation and Energy Act of 2008. This association helped to lobby Congress. Recall we had hearings by Congress in 2004, 2005, and other years that led up to the reopening, as it were, of Pickford 2. So we see that this Judge Friedman, has issued an order. And when we see the very first paragraph there, it says Section 5E13. And he says Section 5E13 of the settlement agreement in this case. The settlement agreement in this case is a document that was 110 pages. And the settlement agreement, in other words, every lawsuit, every class action, particularly the 5 that we've talked about, will have some form of an agreement, a document. In Pickford 1, we call it the Pickford Consent Decree. Here we have the Henry Black Farmers Discrimination Litigation Settlement Agreement. The Native Americans had a settlement agreement. And then the Hispanic and female farmers and ranchers were combined, and it's referred to as the Hispanic and Female Farmers and Ranchers Voluntary Claims Process. And we talked about this a couple of weeks ago. It had a framework, not a settlement agreement. We've gone from consent decrees, settlement agreements to frameworks, but the judge now has issued an order in that second lawsuit, Pickford 2, and he's referencing the settlement agreement. That settlement agreement was revised and executed on May the 13th of 2011, and we're going to see in a moment where Judge Friedman allowed the parties, the lawyers representing the black farmers and the lawyers representing the defendant, USDA, he allowed those parties to amend this lawsuit. And he says that. He says, as amended by the court on April 7th of 2014. He said, it provides for the distribution of unclaimed settlement funds to Cypres. And I pronounce that, it's spelled C-Y-P-R-E-S. I pronounce it Cy, S-I-G-H, Pray, P-R-A-Y. Cypres beneficiaries proposed by class counsel. Here again, when he talk about the parties, lawyers representing the claimants are called class counsel. That group of lawyers, I think there were about 25 different law firms representing the black farmers in Pickford 2. And provided by the court. He says this provision states that such Cypres beneficiaries must be either, and he's getting ready to define what a cypre beneficiary is, at least as it relates to that settlement agreement. Now, we see here that there are two definitions, an A definition and a B definition. We're talking about a cypre beneficiary. He said they must be either a law school that has a low-income taxpayer clinic or program that provides tax advice or assistance to class members, meaning Pigford 2 individuals, class members who have received an award under the settlement agreement and that has been approved by the court. Or definition B, or cypre beneficiary B, a tax-exempt nonprofit organization other than a law firm, legal services entity, or educational institution that is providing agricultural business assistance or advocacy services, including assistance under Pigford and the consolidated case to African American farmers. Judge Friedman says, I want to rehearse. Judge Friedman says, I know what the parties fashioned. I know what they fashioned and what I signed back in May of 2011, and I know what we amended in April of 2014. And in that entire settlement agreement, under paragraph 5E13, it talks about who will be designated or who will be the beneficiary of the funds that may be left over for individuals who have not yet, for whatever reason, claimed those funds. In other words, there were roughly 18,000 African Americans who got, or families who were designated, who were approved by the adjudicators and arbitrators in the Pigford 2 lawsuit. And the lawyers contemplated, they thought about it and considered the fact that, well, in similarly situated class action lawsuits, there will always be, for a variety of reasons, why people do not claim or will not claim their money. In this particular case, $50,000 checks were unclaimed. Maybe someone died. Maybe they moved. The check was sent to an address, couldn't find the person. They moved the hither, they moved the thither, and they moved the yon. Nobody knows where they are living because maybe some folk didn't want their kinfolk to know that they were in the lawsuit. That could be a reason. But for whatever reason, there are funds, there are dollars. Could be as much as $100 million, maybe $250 million, maybe $300 million. Remember, Congress set aside two categories or funds. In 2008, Congress set aside $100 million. And then in 2010, President Obama signed an act to allow those individuals who were late to receive the full measure of relief and to make sure that they had what is called a meritorious claim of relief. At the end of the day, after 2010, there was $1.25 billion in this pot, in this fund. Historically, there are some sources that say that maybe the amount of unclaimed dollars could be as much as 2/3. So that's why I'm saying 2/3 of $1.25 billion. If I might be able to change the phrase, that's like 1,250 million. 1,000 million is a billion. 1,250 million, as it were. 30% of that could be what? $300 to $400 million. If that is the case, and let's assume that they can't find 3,000 of the 18,000, that means the remaining 15,000 would be the parties that they're talking about here. Those 15,000 individuals could receive that money. And we're going to talk about what this association is doing in a moment to make sure that they get just that. Now, as we said, the judge here has written this letter and basically his order. And I'm going to turn over to page 2. The order has 3 pages. I'm going to turn over to page 2 and start at that first full paragraph there, about 1/3 of the way from the top. The judge says again, in view of these authorities, he's talking about the cases that I didn't read. He cited case law. He cited statutes. He said, in view of these authorities, that means some other court, some other judge somewhere has made a ruling similar to the ones that is affecting the parties in question. At the end of the day, the judge is saying there's all this money left over. And apparently he's having some hindsight reservations because he issued this order. It wasn't necessary for him to issue the order if he was going to do what he allowed the parties in the settlement agreement to do back in April of 2014. So that speaks volumes about the fact that he is now saying, not so fast. I may not do what the lawyers are saying. I might consider something else. And he says, in light or in view of these authorities, the court believes that before class counsel, meaning your lawyers, or the lawyers representing, not your lawyers or our lawyers, BIFA has its own. We'll get into that in a moment. But class counsel, the lawyers representing the 18,000 families. He says, before class counsel begins to the process contemplated. That's what he said. Meaning, we talked about in section 5E13, it's contemplated, it's posited, it's somewhere, it's codified in section 5E13 of the settlement agreement of identifying potential cypre beneficiaries. He's not talking about the 18,000 folks now. He's talking about those 2 groups, this law school and these advocacy groups and folks who help black folk fill out the taxes, et cetera, et cetera, et cetera. He says identifying potential cypre beneficiaries and proposing an allocation of unclaimed settlement funds, the court should determine whether a cypre distribution should be made in this action or whether instead some or all, emphasis added, some or all of the unclaimed settlement funds should be distributed to class members. Class members meaning the remaining families, the 15, 16, 13, 14, 15,000 folk who were able to get a check and who were able to cash the check. What he is saying is, maybe I need to do something else. This association is going to file a complaint within the next probably month. In that complaint, we're going to ask the court to, first and foremost, get an injunction against class counsel, against the claims administrator, and against anybody or entity that might have a hand, as it were, in the disbursement of these allocated funds, as it were, the remaining funds, the money that could be the 200 million, could be 300 million. We're going to file a complaint. Number one, as I said, asking the court to enjoin, that means to stop, and to file, in addition to that, stating that our attorneys believe that Congress intended for every dime of that money to go to the remaining families, the victims of discrimination, not some law school, not some advocacy group. We're an advocacy group. but we are saying no other entity, not the ones listed, the law schools, etc., etc., etc. But here again, to the victims, their heirs, administrators, and or assigns. We're going to talk a little bit more about that when we come back. Here again, he says, instead, or whether instead, some or all of the unclaimed settlement funds should be distributed to class members. He says to assist the court meaning him, Judge Friedman, his court, to assist the court in its consideration of this and related questions, the court directs the parties, meaning the lawyers now, the difference between class counsel and the parties more inclusive. He then talks about both class counsel and the lawyers representing the defendant, USDA, which would be lawyers from the Justice Department. He says the court is going to direct the parties to file briefs of not more than 30 pages addressing the following issues. Now, basically, we talked about what is the definition of a brief. Is basically a statement in a lawsuit where lawyers from side A are going to argue why they should prevail, or arguments on side B are arguing why they should prevail, and they use a lot of case law. As he said, they will cite cases, they will cite statutes, and they will talk about U.S. policies and the Constitution and amendments and just all sorts of documents, legal documents to support their argument. He says, I want them to do or to submit to him briefs of not more than 30 pages. But again, our lawyers, on behalf of this association, we're going to file a complaint for the reasons that I mentioned. We do not believe, and if I say this, I don't think I can say this too many times, we do not believe that Congress intended for anyone else, because all of the monies that are available to all of the potential claimants in all of these lawsuits, those monies are the result of Congress. That is to say, Congress then, if Congress is going to set aside $1.2 billion, that means it's taking money from taxpayers. It's using the taxpayers' money to pay its bill, to pay its debt. The United States Department of Agriculture has created a debt by discriminating against individuals. They created a debt in October of 1999. Congress passed the Appropriations Act of 1998, which blew life into the first lawsuits. And it said that the money would be available from the judgment fund. In other words, we're saying that Congress did not intend to use taxpayer dollars to pay anyone other than the victims of racial discrimination. But for racial discrimination on the part of USDA, there would not have been a lawsuit. It would not have been necessary for Congress to set the monies aside. We're going to argue that the only individuals would be the heirs, the victims, to whatever extent those victims are alive, their heirs, administrators, and or assigned. And here again, not to some law school out in hither or some tax organization in thither or an advocacy group in yon. Be back in just a second. The judge has raised some issues. As he said, he wants them to file briefs regarding and addressing the following issues. Issue number one, the judge says, if the case law presumes that identifiable class members are entitled to the distribution of any excess funds when feasible, why shouldn't the court attempt to further that goal, which was, of course, the whole purpose of this litigation, rather than providing those funds to disinterested third parties? So we see here clearly that the judge now has changed his position regarding the Cypre beneficiaries. As I said, he's now considering, and as he said, if case law, remember, I was saying that that's basically what a brief is. The lawyers are going to look through a bunch of cases, and they're going to look through a bunch of documents and amendments to the constitutions and statutes and prior rulings from this court and that court, the Supreme Court, the appeals court, this circuit court, another circuit court, et cetera, et cetera, et cetera. And they're going to come up with case law that says, we believe you ought to do it this way, Your Honor. He says, then I still might just give it to the victims. Then he goes on to question number 2, issue 2. He says, absent agreements of the parties, he says, let's suppose the lawyers representing the claimants, the lawyers representing the defendant, if they can't come up with agreement, does the court, meaning himself, does the court have the authority under the settlement agreement, Rule 60 of the Federal Rules of Civil Procedure, or otherwise, to provide for the distribution of unclaimed settlement funds to class members rather than to Cypre beneficiaries? So we see so far, under number 1, he's favoring class members. Under 2, he says, I'm favoring class members, not Cypre beneficiaries. Then he goes to number 3. Do any acts of Congress? Here we go. This is where I think we're going to hit pay dirt. Do any acts of Congress pertinent to this case, such as the Food Conservation and Energy Act of 2008, way to go, Your Honor, or the Claims Resolution Act of 2010, yay, bear on whether it would be permissible or appropriate to provide for the distribution of unclaimed settlement funds to class members? On that point, number 3, the answer as far as we're concerned is unequivocally yes. The Food Conservation and Energy Act of 2008, the Claims Resolution Act of 2010 makes it crystal clear, makes it extremely clear, abundantly clear, again, that Congress did not intend for anyone other than these groups to get that money. We're going to do all that we can to make sure that they do. I'm going to come back and read just a short paragraph from one of those acts, the Food Conservation and Energy Act of 2008, which we believe provides for, or at least shows that at least Congress intended for that money to go to the victims of racial discrimination. And in this particular case, Pickford 2, and in the Pickford 2, those families who received the funds and not to anyone else. And as we said, June of 2008, as a result of the lobbying, as a result of the hard work, as a result of going from Congressman A, B, C, D, X, Y, and Z, asking them to consider reopening the lawsuit. Remember, in 1999, Judge Friedman, in the consent decree, there was a paragraph called paragraph 5G that talked about anybody who filed a claim after October the 12th of 1999 in that first consent decree would be considered late. And Mr. Attorney Michael K. Lewis designated these late filers. Then we finally got Congress, not the court now. We filed a motion to Judge Friedman's court in 2004, but he denied it. He said he didn't have the authority then to modify the consent decree. Well, what looks like he's going to do just that now. Maybe some constitutional law or amendment passed that now gives him the authority to do just that. But at any rate, he is considering it. He says now that in number 3, is there an act of Congress? Yes. Congress passed the Food Conservation and Energy Act of 2008, and under sections 14011 and sections 14012 or 14012 as we refer to it, particularly 14012. Now, we talked a couple of weeks ago about why we believe black males, that Congress intended for black males to be included in the Hispanic lawsuit. And there were two sections in this farm bill that addressed both of these groups. And this is why we filed the lawsuit against the claims administrator in Portland, Oregon, for violating black males' right under Title VI of the Civil Rights Act. We said then, just to refresh you now, that Section 1411 was a sense of Congress. We're not going to read that, but it will be available on our website. It says everybody who didn't get in the Pickford lawsuit, everybody who missed Pickford 1 and everybody who missed Pickford 2, there was another provision for those individuals. And this is where the Hispanics and female farmers and ranchers got in. We said that language was also inclusive of any other individual, whether he was African American, whether he was Hispanic, or otherwise. But now the section of that act that speaks succinctly and directly to what the judge is asking and is the basis upon which our attorneys is going to be filing that complaint is Section 14012. That's 14012. It says determination on the merits of Pickford claims. It goes on to give a definition. But then it says what, under number 3, it says a Pickford claim. The term Pickford claim means a discrimination complaint as defined by Section 1. Notice they're using the word what? Discrimination. Congress says we're setting this money aside for individuals who have a discrimination complaint, not somebody who has a tax office, not somebody who's doing a good thing for black farmers. There are a lot of folk doing good things for black farmers. We believe we're doing good things for black farmers, but we believe the money should go to the victims of discrimination. So it goes on to say that discrimination complaint as defined in 1H of the consent decree and documented under 5B of the consent decree. Now, here's where we believe Congress is hitting the nail on the head. Number 4, a Pickford claimant. Now, notice in 3 they said a Pickford claim. Now they said the Pickford claimant. The term Pickford claimant means an individual who previously submitted a late filing request under paragraph 5G of the consent decree. Those are the individuals that Michael Lewis denied. They were designated as late. We filed a motion in Judge Friedman'S court in 2004. He denied them. So then we went to where? Congress. Hello. We went where? Then to Congress. Sometimes if you can't get what you're looking for from the courts, you go back where? To Congress. Congress then, after 3 or 4 years of lobbying, they met and they passed the Food Conservation and Energy Act. And in Section 14012, they said, wait a minute, we're going to go back now and take care of those individuals who were left out by Michael K. Lewis and others. Now, I have to make this statement. We're having some members calling the office and saying, well, wait a minute. The Pickford 2 people got paid in 2013. They're no longer members of this association. They got their money. Why now should this association go back and help the people who've been paid? And for all intents and purposes, most of them are not members. But here's a point that we made then, and I think this point now, and I hope you can have developed an appreciation for why it is necessary in the African American community, whether it's in the farming community or the X community or in the Y community. We have to have an advocate. We have to have someone who is independent enough, some agency that is independent enough. Now, notice I said that BIFA was going to file a quote unquote complaint in court, fighting for the individuals in Pickford 2, fighting for the individuals who've been paid. Now, I might add also, BIFA, this association, is the only, let me say it again, it is the only civil rights organization that is filing on behalf of this group of individuals. We have often said that these lawsuits, rightly understood, have created and can be the basis of an economic development platform for which we can continue to grow, economically speaking, for which we can continue to create businesses. When you're talking about these lawsuits combined up to this point, there's been maybe $4 to $5 billion worth to be. That's a lot of money for our community. You would think there would be other civil rights organizations, whether they're in agriculture or elsewhere, representing African Americans in this endeavor. We also believe that the lawyers representing these individuals, class counsel, will probably not do anything different or differently from what they have already decided. As the judge said, they contemplated when they created these settlement agreements in 2011, and when they amended it in 2004, they never said one time, it ought to be a good thing to just give the money back to the victims of discrimination. They never said that. So if they never said it then, and I believe the judge is prepared for that because he's going to deal with that in number 4. And he's also says, I may just do it no matter what these guys say. But what does this mean? We always need an association to represent our interests. If you're not a member of this association, become a member. There will always be other benefits and opportunities. It's not over, and you've heard me say this at meetings. It's not over when you get the $50,000. It starts. The lawsuit is not the end of our being compensated for wrong. It is the beginning. This order from Judge Friedman, in my opinion, is proof positive of that position. Now, number 4, the judge is saying, if the court has the authority to act sua sponte to provide for distribution of unclaimed settlement funds to class members. What he is saying is that sua sponte is a phrase that means I really don't need anybody's authority. I can do it unilaterally. I can do it on my own. In other words, if the lawyers don't do it, if the lawyers representing the claimants don't agree to it, if the lawyers representing USDA don't agree to it, I believe I have the authority to act on my own. He says to provide for the distribution of unclaimed funds. And I might say this, we are hoping that if he needs a little bit of a motivator, that complaint that we're going to file will help him to what? Make sure the scale is tipped in the favor of the people who are discriminated against. In other words, he says if the court has the authority to act sua sponte to provide for the distribution of unclaimed settlement funds to class members, either through modification of the settlement agreement, meaning now he can go back and modify the settlement agreement, which is what we asked him to do back in 2004, some 11 years ago. So much for that. He says either through the modification of the settlement agreement or through other means. What legal standards should the court apply in determining whether taking such action would be appropriate? Here again, I believe our attorneys is going to give him a plethora, a superabundance of authorities and reasons as to why this action is, quote unquote, appropriate. And number 5, lastly, he says, in the interest of transparency, should the court schedule a public hearing inviting class members to offer their views regarding these issues? The judge says, I'm going to do this in broad daylight. I want to be open. I want to make sure this is done with the utmost degree of transparency. To that extent, I've got a courtroom, and I might just schedule a public hearing inviting the victims themselves, inviting the people who've been discriminated against themselves, not the lawyers representing the Department of Justice, not their lawyers, but I want to hear it from those individuals who believe that they are the ones who should get the money. And here again, we will try to make sure, or as I said, we may not be we'll be at the hearing, but we're going to go one step further. Up to this point, everything in 1 through 5 is voluntary. Not that we don't think the judge will do the right thing, but just in case, if you are an advocacy group, you sue. You've heard me say it oftentimes. If somebody tells you they're a civil rights organization, the first thing you ought to ask them is, who are you suing then? Because if you're a civil rights organization, that means you are there to protect the rights of your members. And the way you protect the rights of your members, you enforce the rights of your members. You don't leave it up to somebody's whim. You don't leave it up to somebody's discretion. You file a suit. So if you're not suing anybody, on the one hand, the only deduction is, well, maybe your members are not being discriminated against on the other. Because if they are being discriminated against, and if you are representing the people who we represent, they've been here 400 years, and yes, we are being discriminated against on a daily basis. So then your civil rights organization, your advocacy ought to be suing somebody to make sure that you get the full measure of relief. We've said again, these lawsuits, rightly understood, let me say it again, these lawsuits, rightly understood, can and have, if we understand them, provide an economic foundation, a base upon which we can launch our endeavors into other businesses with these proceeds, not only from the money that's left over. And this is why we're fighting so hard to make sure our members are included on every level. That's what we do. We are a civil rights organization. And if people are violating our members' constitutional rights, we got to sue somebody. And that's not a negative statement. That's not a verbose statement. It's just what you ought to be doing. Here again, if you're a member of a civil rights organization and they're not suing somebody, you need to call 901-522-8880 and become a member of this association. Now, I think it's worth note that this last sentence is worth noting, rather. He says, the parties are not limited to these issues, and their briefs may address other issues that they believe are germane to the court's review of the cypre provisions of the settlement agreement and its consideration of what course of action to take. The judge said, I named 5 reasons, but you're not limited to that. You can address, and as he said, he gave the attorneys the opportunity to submit 30 pages worth of arguments. And but as long as he said, it's germane. When something is germane, that means it is unique to, or it is coincidental to. Germane doesn't mean we're talking about apples, and then here someone comes up and start talking about strawberries. Strawberries are not germane to apples. He says, everything you put in that brief ought to be germane. It ought to be specific to the issue of how do we disperse the monies to this cypre beneficiary. Again, our position is, Your Honor, with all due respect, our attorney's going to file a complaint on behalf of not only our members, but for the benefit of all African Americans, those who are not members. We hope that you will become a member. We believe that, and we said this, you've heard me say in the meetings, in my opinion, every time we had a meeting, the person who had already gotten a $50,000 check should have been the first person at the meeting, because they stand to gain, they stand to benefit more than anybody, because the courts have already adjudicated, has already stated and found that they are the victims of racial discrimination. So there will always be other benefits accruing to them. But here again, for whatever reason, people got paid and they left. Now we see that they may be leaving money on the table. If you have never been a member of this association, but if you are one of those 15,000 individuals or so that might be the beneficiaries of our efforts, call this office. We hope that this video will be available in time for you to meet us in Washington, D.C. on Monday, September the 21st, in a few days. We're going to be, since the judge says he wants some transparency, he wants the world to know what's going on, then we're going to up the ante just a little bit more. We're going to be out, not in his courtroom, but we're going to be outside of his courtroom marching and protesting for what we believe, Your Honor. It seems like you're doing the right thing now, but we believe you've allowed USDA to get away with too much, though, up to this point, and we want the world to know that as well. Join us in Washington, September the 21st, 2015, in front of the E. Barrett Friedman Courthouse, which is located at 333 Constitution Avenue, Washington, D.C. at 10 a.m. Thank you and goodbye.